that in determining the constitutionality of sections 39.2 and sections 39.3 of the Constitution, the appropriate article of the Constitution which the High Court needed to refer to was not, my Lord, Article 86 and Article 138.2, but Article 138.3c, as read with Article 138.10. We submit, my Lord, that until the four actions that I highlighted earlier on in my submissions that are directed to be done by that the Constitution directs or enables the appellant to do under Article 138.3c.
And that's Advocate Paul Nyamodi there addressing the Court of Appeal judges on the first day of the hearing in a contention where the IEBC is appealing a High Court ruling that effectively enforced the constitutional requirements that votes are counted and announced at the constituency level, which means the constituency polling stations. This hearing will go on for 2 days and a determination must be made well ahead of the election for the IEBC to prepare. That is the contention at the Court of Appeal. We'll be going back to the Court of Appeal much later. But first, let's cross over to the Radisson Blu right now, where Hudhaifa Eden is on standby as the Orange Telecom seeks to yet again rebrand and make the brand more visible. Hudhaifa, good morning to you, and can see behind you the preparations are on to ensure that this is a success. But speak to us about the success of Orange Telecom and what has prompted this decision to once again rebrand.
As you can see underway, Telecom, the oldest telecommunication company in the country, Telecom Kenya, is set to rebrand today. Of course, this is after the formal exit of its majority owner, France Telecom, and the entry of Helios as the new partners and the controlling shareholders, because government owns 40% and the majority shares, which stand at 60%, being owned by Helios. Preparations, as you can see here, are right underway. We are expecting industry leaders. We expect the CS for ICT, Joe Musheru. The president was as early expected to come, but we've been told now that he's going to Kisii for a certain political event. We see even industry leaders. We have Safaricom executives here. We have the regulator of the Industry Communication Authority, Wangusi, is set to equally grace the occasion. A lot of activities set to happen here today, but as we hear that they will be given their strategic direction today. Actually, what I heard from their CEO, Aldo Maurice, is telling me that they'll be going big on data because that is where the competition is right now moving. Of course, moving from voice, moving from SMS because of the over-the-top service providers such as WhatsApp, such as Viber and Facebook. They are now going big on data. Ken.
Hudhaifa, thank you. We'll be crossing back over to you at Radisson Blu to speak to you and to take that event live as Orange Telecom, or Telecom Kenya, the biggest and the oldest telecommunication company in the country, rebrands after their majority shareholder left. France Telecom left, and right now the other partner is Helios, and we obviously know that the government holds a majority stake in this telecommunication organization that is the oldest in the country. Right. As we mentioned earlier, we will be taking you back to the Supreme Court, and just a background as we show you some live pictures, we'll be going there live, is that today the Court of Appeal is hearing the case of the Independent Electoral and Boundaries Commission that is appealing and challenging the announcement of presidential results from the constituency level as final be determined on an urgent priority basis. Basically, what happened is the High Court judges of Aggrey Mushelule, Weldon Korir, and Enoch Chacha Mwita on April 7th declared that the presidential results at the constituency level, as announced by returning officers, are final and should therefore not be subject to any alteration by the IEBC at the national tallying Center, and the IBC now claims that the returning officer, that ruling that was given by the High Court gives the returning officers the power to declare presidential results, which is contrary to the provision of the Constitution, and that's the reason why they're back in court appealing that decision. Let's take you live now to the Court of Appeal, where the hearing is underway.
Of elections or the electoral system in this republic. My Lord, it presented its report to the two principals as they then were on the 17th of September 2008. And my Lord, that report is the document that informs the structure of our electoral system, the structure of the appellant, and the manner in which the appellant conducts its mandate. My Lord, because of the importance of that document, we, on behalf of the appellants, have taken the liberty of attaching the entire report in volume or in the appellant supplementary list and bundle of authorities. And my Lord, that report is to be found between pages 73 and 237 of the appellant's supplementary list. My Lord, it makes very interesting reading in respect of the conduct of elections in this republic, but I wish to refer your lordships to a few specific provisions of that report. My Lord, I wish to refer you to page 191 of the supplementary list of authorities, and this is chapter 6 of Kriegler's report. And in chapter 6, he is dealing with counting and tallying of the 2007 election results. Counting and tallying. My Lords, page 191 from line 16. The paragraph beginning on line 16, where it begins, in the meantime. May I proceed? In the meantime, the ECK commissioners would normally have announced results from the constituency once the fax and telephone message had been received and been data captured. Fax and telephone tells you this was a long time ago. I don't think there are any fax machines in any offices anymore. But we go on. I beg your pardon? Oh, yes, we can replace that for the equivalent. But I proceed, my Lord. If there were no differences, when these were checked against the original Form 16, the results changed from provisional to final. That is, the official ECK-approved presidential results from the particular constituency. Because the original Form 16 was now with the ECK, it sets out clearly the procedure that took place in 2007. What was not foreseen was that the returning officer might have realized that there were inaccuracies or even more serious mistakes in his Form 16. As the content of Form 16 would already have been communicated to KICC and also been announced, there was a serious problem, and the announced results ought to be changed. The ECK had not prepared clear procedures or rules for announced results. The ECK had not prepared clear procedures or rules for this eventuality. IREC has learnt that commissioners disagreed on whether or not changes to the announced results were possible. The same is and was the case even for senior staff, including the Deputy Secretary, the IT Manager, and table team leaders. It goes on in its examination of the electoral process at that point. And I now refer your lordships to page 196 of the same volume, line 16. The paragraph that begins, some returning officers did transfer constituency results. And they say this, my lord. Some returning officers did. There is a point I want to make. And I want to make that point, and that point, my lord, exists in line 20. It says, in some cases, necessary changes were not allowed, resulting in the ECK insisting on results that it knew were wrong. My Lord, this is an official report, and the punctuation at the end of that sentence is important. Exclamation mark.
Where were these mistakes found? Were these mistakes found at KIC, or the returning officers at the constituency find that there was a mistake in what they had committed?
My Lord, the process of elections is a cascading system of tallies. It is additions from the time the votes are counted in the polling stations. We are human beings. It is, if you add, in this election, there are 40,000 polling stations. If you add 40,000 numbers, there will be mistakes. We are human beings, and we need to take that on board. And these are the mistakes that IREC then pointed out. IREC then goes on, my lords, to provide a solution to this problem. And that solution is found in the recommendation in page 211. The recommendation is important, and I will seek your lord's indulgence to read it in its entirety. Paragraph or line 21. IREC recommends that ample time be allowed for verifying provisional results so that they are declared final official only once there is no risk of errors. Only once that there is no risk that errors may still be found and non-frivolous objections raised. Most countries allow 1 or 2 weeks for this. My Lord, I submit that Article 138(10)(a) of the Constitution flows directly from this recommendation. Article 138(3)(c) also flows directly from this recommendation. And Section 39(2) of the Elections Act, which I have submitted is a normative derivative of Article 138(3)(c), also flows directly from this recommendation. And I submit it exists in our statute books so as to keep us away from those unfortunate events of late 2007, early 2008. Anybody urging a contrary position wants to return us to those dark and shameful days. I have submitted, my lords, that Article 138, Sub-Article 3C of the Constitution vests the IEBC with the duty to, after the votes have been counted in a polling station, to tally, verify, and declare the results. My Lord, I think it is important that I point out to the court the manner in which the appellant carries out that important responsibility. My Lord, as a responsible constitutional commission, the appellant has prepared a document called the Election Results Management Framework. My Lord, that document appears in the supplementary list or supplementary bundle of authorities by the appellant. And my Lord, the document is runs from page 19 to page 72. Because it is a document that is written so clearly and so succinctly, I will not take your Lordship's time in walking you through the document. But my Lord, section 4 of the document that runs from page 34 to page 40 of the document sets out the results management operations. My Lord, as is stated on page 32, the purpose and object and principles of this document is to, the purpose of the election result management framework is to ensure that the process of counting, tallying, collating, announcing, transmitting, and declaration of results is transparent, verifiable, secure, and undertaken in accordance with the law. It then sets out... No, the document was not before the High Court. But the process to which the document speaks was before the High Court.
It is a derivative of the regulations.
Yeah. It is a derivative, my lord, of the regulations that the High Court considered.
It doesn't go beyond the regulations.
My lord, it is...
And actually plan to raise an objection with them, because if it is evidence, they should have done it by way of an affidavit. Then we have an opportunity, if need be, to respond to it. I didn't want to disrupt the earlier process when we were doing the preliminaries, but I actually take great exception to the attempt by the appellants to introduce what they are calling their supplementary list and value authorities, and what they are calling a case digest, in which they've sneaked in several pieces of evidence which have never been canvassed, they were never introduced before the High Court. They are being brought before yourselves for the first time.
No, it's not evidence, my lord. And it is a narrative of the regulations. The regulation... My lord, I am relying on it in the same way I would rely on the regulations. We would spend 3 days if we went through the election general regulations.
May I add something? My lords, with your kind permission, I was with Mr. Willis Otieno in this matter in the High Court. This particular document is a public document. It is available to all political parties, all political players, and everybody has access to it. It is nothing new. It's simply a narrative of what is contained in the regulations. So there is nothing new in it. Whether you took it or you didn't take it, it contains simply that which is in the regulations in the form of a narrative which a layman can understand.
My Lord, speaking for ourselves, this is not a public document. As political parties, we have not had access to it. Indeed, my Lords, there was regulations which are still being processed through Parliament as a result of the Election Laws Amendment Act 2017, which brings in a new framework for election results transmission. And that matter has not been driven through Parliament to conclusion. And I think it's totally unfair for it to appear, especially on this last day. This supplementary list, we have not even seen it until this morning.
And further, if you will not take the document as referring to, just looking at the cover, it says that this document is an April, just date only, just on date only. Okay.
Yeah, IEBC.
Okay.
It's a public document.
Amen.
Yes, sir.
It's a public document. It's actually available.
It's not a public document.
The subject of this appeal is a very important national process. And the appeal is necessitated by certain misrepresentations of certain actions of the appellant before the High Court. You will go through the judgment and you will find a reference to results being altered and things like that happening. The regulations that Learned Senior speaks about were gazetted on the 21st of April this year. The election general regulations have been amended. And this is merely a narrative of those regulations. As Mr. Wambua Kilonzo has said, these documents are available and they have been supplied to political parties.
Yes.
Yes. Yes.
It's okay. Go to the process of election.
I am glad by that assurance from your lordship. I will cling on to it and I will proceed with my appeal. My Lord, the next issue I wish to submit on is what the role of the returning officer, of the constituency returning officer is in the presidential election. It is our submission that he has been assigned a role by the High Court at the instance of the first to third respondents that doesn't emanate from the Constitution or the law. My Lord, a returning officer is, as provided by Section 2 of the Elections Act, one who is appointed to supervise an election by the appellant. There are 6 electable positions under the Constitution, that of President, Governor, Senator, County Women's Representative to the National Assembly, Member of the National Assembly, and Member of the County Assembly. My Lord, it is our submission that returning officers are appointed to supervise specific elections. The Elections Act has been amended by Parliament, and the role of the constituency returning officer is now set out clearly in Section 39(1)(a) of the amended Elections Act. 1 capital A. Big A. And briefly, it says the following, my lords, that, and this is determination and declaration of election results. That is the heading of Section 39. 39(1)(a) now says, the Commission shall appoint constituency returning officers to be responsible for 1. Tallying, announcing, and declaration in the prescribed form of the final results from each polling station in a constituency for the election of member of National Assembly and members of County Assembly. Later on in my submissions, I will submit on what the meaning of a declaration is. Secondly, Roman 2, the Commission shall appoint constituency returning officers to be responsible for Roman 2, collating and announcing the results from each polling station in the constituency in respect of the election of the President, County Governor, Senator, and County Women's Representative to the National Assembly. I urge your Lordships to note the provisions of Section 39(1)(a) Roman 2 in respect to the role of the constituency returning officer in a presidential election. My lords, to conclude this thematic area, I have made the submission that Article 86 or Articles 86 and Articles 138(2) were not the correct articles by which the constitutionality of Section 39(2) and 3 should have been determined. On?
Constitutionality, because earlier on I had you mention and address it at length on Article 138, some other part of Article 138. Does it have any bearing at all?
Does it have any bearing? We are saying 138(2) has no bearing, but is there any part of 138 which has any bearing?
My Lord, I have said, and I will say it emphatically, that the election for the President of this Republic is completely governed by Article 138. And I will state in a moment what our understanding of what 138(2) does. But in the determination of the constitutionality of Section 39(2) and 3, 138(2) has no role. And that is the submission which I then wish to come on to after I have dealt with the submission on why Article 86 has no role also in that constitutionality. My Lord, I submit that the purpose of Article 86 The purpose of Article 86 is to set out the constitutional principle that election results must be promptly announced. Now, my Lord, I am only counsel, so I cannot make that submission without authority. And I wish to rely, my Lord, on two authorities in support of that submission. My Lord, on page 278 of the Record of Appeal, the decision of the, at line 23. The Record of Appeal, page 278. At line 23, my lords, the learned judges of the High Court pronounced themselves as follows. Article 86B and C demand that there must be promptness in the announcement of election results. That is the finding by the High Court. And I submit that is the purpose of Article 86. The second authority I wish to rely on, my Lord, is the decision of the Supreme Court in the Joho matter. And I wish to refer your lordships to volume 1 of the applicant's list of authorities, page 39, at paragraph 97 of that decision. Page 39 of volume 1 of the applicant's bundle of authorities, page 39, paragraph 97, which commences on line 29. The Supreme Court pronounces itself as follows. The wording of Regulation 87.4a shows that the Gazette notice, in case of the presidential election, is specifically used to declare the winner of the presidential election. Indeed, this is within Article 138.10 that states that the chairman will declare within I'm sorry, I think that is the wrong reference. It is 93 on the paragraph 93 on the next page. I'm sorry, my lords, page 38 on the previous page. It is paragraph 93, and 93 says as follows, that the Commission is further mandated by the Constitution, in brackets Article 86B and C, to ensure that the results from the polling stations are openly and accurately collated and promptly announced by the presiding officer at each polling station, and the same to be done by the returning officer. That is the purpose of Article 86. That decision of the Supreme Court was binding on the High Court, and I submit respectfully is binding on this court.
Yeah. Yeah.
This is the difficulty with the reliance on the Joho decision. The Joho decision deals with the election of a governor. And I had submitted previously that the election of the president is dealt with by a different constitutional standard. And that is why I had said earlier on in my submission that the finality envisaged by Joho and by Stephen Kariuki is achieved in the presidential petition once the duty placed on the IEBC by Article 138.3c is fulfilled. That finality is not, and we agree that there must be finality, and we agree that there is finality. In all the other 5 elections, it happens differently from the presidential election. And because the other 5 elections are not the subject matter of this appeal, I will not dwell on it. Suffice it to say that in the presidential election, the finality in Joho and Stephen Kariuki is achieved once the duty in Article 138.3c is fulfilled. My Lord, there was a question from the bench as to whether Article 138(2) should apply to the consideration of the constitutionality of Section 39(2) and 3. My answer to that is no. Article 138(2) does not provide for the manner of declaration of the presidential result. My Lord, the manner of declaration, and this is why in response to your Lordship's question I said that Article 138 is self-contained. The manner of declaration for the election to be conducted as directed by Article 138(2) is to be found in Article 138(3)(c) as read with Article 138(10). Article 138(3)(2) can be contrasted with the provisions of Article 180, subarticle 4 of the Constitution. Article 180, subarticle 4 is a similar provision of the Constitution that directs the election for governor, and it provides as follows. If two or more candidates are nominated, an election shall be held in the county, and the candidate who receives the greatest number of votes shall be declared elected. That's a self-contained article. If you look at Article 180, subarticle 4, there is no need to look elsewhere for declaration. But because 138(2) is not self-contained, you need to look elsewhere. And it is our submission that the right place to look is not 86, which merely provides that election results should be announced promptly, but 138(3)(c) and 138(10). My Lord, as I move on from that point, in respect of Article 138(3)(c), the comma at the end of the first sentence after the word polling station is important. And we submit that the meaning that comma introduces into that important provision of the Constitution is that the only act that takes place at the polling station is the counting. The only act that takes place at the polling station is the counting in respect of the presidential election. There is a submission which perhaps I would like to respond to directly at this point by the sixth respondent in their written submissions. This one, I give it. This one. My Lord, the sixth respondent in their written submissions at paragraph 47, in respect of the ability to verify or the responsibility to verify placed on the appellant, state as follows. The power of verification of results under Article 138(3)(c), and which is shared corporately by the entire Commission. This power of verification and not alteration is shared by returning officers of each constituency in terms of Article 138(3)(2), again a misreading of that important article, and who alone can A, tally, B, verify, and count of the polling stations, and C, declare the results. The only thing that takes place at the polling station is the counting. The verification, the tallying and the verification take place elsewhere. And they take place.
Count and announce. Do what? Count and announce. You count and announce. Yes. The presidential result is made up of 40,000 components. The single block of a presidential result is that polling station. And it is those that are then tallied. They are tallied by the constituency and they are tallied by the IEBC as directed by Article 138(3)(c).
That article 138(1)(c) says, after counting the votes in the polling stations, the IEBC shall tally and verify the count no mention in that of any announcement. It just says you move from counting, you go to tallying and verifying. There's no announcing in 138(1)(c).
It would be.
Unless there's amendment to the Constitution.
No, there hasn't been an amendment to the Constitution, my Lord, and if there had been,
What do you make of that?
my Lord, it would be the kind of election, if that were to be the position, it would be the kind of the election, it would be the kind of election that some of the respondents accuse the appellant of conducting. It is imperative that the results of an election be announced at every stage and at the earliest stage possible, and that is the polling station.
So you're trying to make a distinction between IEBC as the chairman and commissioner and its employees.
Yes, there is a distinction, and there is a very clear distinction, and I will submit on that point later on. They are not the same.
Not a question of principle-agent relationship.
They are not. It is not a question of principal or agent relationship, because even if they are agents, then there is no. Even if returning officers or presiding officers are agents, there is no evidence in the law or in any submissions before your lordships that the principal has delegated the ability to tally, announce, and declare to those agents.
If you look at 139(1)(c), look at it. After counting the votes in the polling station, the IEBC shall tally, verify, etc. The thing, tallying and verifying is done by the IEBC
Yes, it is.
over there.
Yes.
But the counting is not done by the IEBC.
No, the counting is done. The election is conducted by the IEBC. So, my lord, to say that anything in the election is not done by the IEBC, I think would be admitting that it is an unconstitutional election. But the point I make, and the point that perhaps I wish your lordships to record, is that the counting is done at the polling station, and the verification and the tallying are then done as directed by the Constitution by the IEBC.
The counting is done by the IEBC at the polling station. Or who does that?
Presiding officer.
My lords, I have taken you through the provisions of section 39(1)(a) of the Elections Act, and it seeks to operationalize the provisions of the Constitution. And the manner in which that is done is then set out in that provision of legislation. The polling station is under an officer known as a presiding officer. And the presiding officer is the only one actually who counts votes. Nobody else counts votes in an election. Like I said, after the presiding officer has counted votes and announced, because there is indeed a distinction in election law and practice between an announcement and a declaration. And we acknowledge that a presiding officer can only announce. Once he announces, then it is a cascading system of tallies. And declarations then take place at the logical point where the election ends. If it is an MP, it is the constituency. If it is a governor, a senator, a women's representative to the National Assembly, it is the county. And if it is the president, then it is the national level.
You're saying that the IEBC introduces two levels. The counting level, the registration level. Is that what you're saying? That's why you're saying this point is very important?
That's correct.
It is correct, because the duty placed directly on the IEBC then happens after the comma.
Or the comma is at the polling station?
It's at the polling station.
Otherwise, the polling station would come afterwards. It would be not come.
The effect of that argument is that what takes place before the comma is not by the IEBC.
Article 188, I think, answers that.
That's not by your construction. Before your construction, the IEBC can't connect that.
The IEBC has the ability, under the Elections Act, to appoint presiding officers who supervise the election at the polling station. And when I say it happens at the polling station, it happens at that level. I think the question that came from your brother was that then are we saying that that then is not the IEBC?
In fact, I'm thinking that
Closer.
supposing that article read, after the counting,
of the votes at the polling station,
comma, the IEBC. I mean, that would then happen in what you're saying. If the constitution is read after the counting, comma, the IEBC. But now the different article that is missing, does that not change everything?
No, it doesn't. It doesn't, my lord, and I believe it says what you're saying. Because it says after the counting, after counting the votes in the polling station. So what is being counted is votes. And where it is being counted is at the polling station. Then the other actions then take place. I need perhaps maybe just another 15-20 minutes to conclude the second thematic area, which is smaller than the first one.
And then there are two areas.
I beg your pardon? Then we have two to go.
We should reorganize the time.
My lord, the first thematic area in the...
For the record, my lords, I hope that any transgressions of my panel colleagues will not be visited on me. Because I still require my lords my 45 minutes. I'm most obliged. I'm most obliged, my lord.
I was hoping on a small donation but I will proceed.
My lord, if he has an extension, it should then follow that we'll have an extension.
Let's proceed.
Yes, proceed.
Now, the next issue I wish to deal with is the difference between an announcement and a declaration of election results. Now, this has been dealt with extensively in the appellant's written submissions, and this is covered between paragraphs 8 and 22 of the written submissions. I will not go through that in any length, but what I wish to highlight, or what I wish to emphasize as I am on my feet, is what we propose as definitions of these two important terms or concepts in election law and practice. My lords, I submit that an announcement of election results as envisaged by the Constitution and the Elections Act and the regulations made under the Elections Act means the making election results publicly known. The reasons why we arrive at that conclusion are set out in our submissions. And I wish to submit, my lords, that in respect of a declaration, we submit, my lords, that a declaration is a formal pronouncement in the electoral process by a person authorized either by the Constitution or the law to make the declaration, which pronouncement, my lords, brings the electoral process to an end and determines the result in an election. My lord, I submit that it is the declaration that gives rise to the finality that is referred to in Joho and Stephen Kariuki. My lords, I have referred your lordships to section 39(1)(a) of the Elections Act, and it states that what elections a returning officer is able to declare. And my lords, Articles 138(3)(c), as read together with Article 138(10) of the Constitution, then state clearly the manner and by whom the presidential election result is to be declared. Finality flows from declaration. And therefore, my Lord, we submit that the finding by the High Court that the declaration of the result in a presidential election by the constituency returning officer is wrong.
So as an announcement, just someone shouting or some documentation?
There is some documentation, but that documentation does not result in a declaration. And we have said that there is a distinction between declaration and announcement, because the declaration is only possible by an officer authorized by the Constitution and the law, and it then brings the electoral process to an end.
Issuance of Form 37.
No, the forms have changed.
Oh, okay.
Looking at the orders issued by the High Court, going to 1994, paragraph 67, to E.
What page, my Lord? Yes, my Lord.
They used in all those paragraphs the word declare. If they used announce,
when they use the word declare, then there is finality. And when there is finality at the constituency level, then the responsibility vested on the IEBC by Article 138(3)(c) cannot then take place, because there is finality, because there has been a declaration. That is the difference, my Lord, between a declaration and an announcement.
Living for a moment, declaration, living up, and going back to what you yourself said.
As at the moment,
Going back to what you yourself said. At the moment, the returning officer at the constituency either announces, makes known, or conveys the outcome or the result of the elections there at that moment. Is there finality as far as that constituency is concerned?
In a presidential election, no.
How do you then account for if there are changes that occur at the later stage and the announcement has already been made at the constituency level?
I will show you, I will demonstrate to the court the regulations, and that is what I wanted to show the court in the results management framework, the process by which the verification takes place. And that process includes an interaction between the IEBC, the returning officer, in respect of which the constituency where there is a change, and the chief agents who are. That is how the verification process. And verification works in this way. I think and there is no arithmetical error. And the errors that are being addressed are the errors that were pointed out in Kriegler's report. No other errors. And that is why the Constitution and the Elections Act is worded as it is. If there is no arithmetical error, either plus or minus, then the verification is complete. If there is less, then the correct figure is announced. And if there is more, then the correct figure is announced. And I think that is a duty or a responsibility implicit in the duty placed on the IEBC to verify. Yes, there is. And I will point that out in the regulations, and that is what the results management framework sets out. I've covered my two thematic areas, and I want to complete, my lords, by submitting as follows. That in respect of the declaration of the results, my lord, in the presidential election, the returning officer, the results are declared by the returning officer of the presidential election. My lord, there is no contestation that the returning officer in the presidential election is the person appointed by the IEBC to be the returning officer of the presidential election. And I submit, my Lord, in deference to the provisions of Article 138(10) of the Constitution, that is the chairperson of the IEBC. In a presidential election, the returning officer referred to in Article 138(c) of the Constitution is not the constituency returning officer. Because the constituency returning officer is not appointed as such for the purposes of the presidential election. Presidential election were to take place on its own, constituency returning officers would need to be appointed so that the presidential election would be executed. But bearing in mind the provisions of Section 39(1)(a) of the Elections Act, for the presidential election, they would be appointed without the ability to make a declaration in the presidential election. Because Section 39(1)(a) Roman 2 sets out their responsibility in a presidential election, and it does not include declaration. My Lord, if the finding by the High Court is to be, for even for a moment, to be deemed as correct, there would be 290 declarations. And there would be 290 presidential election results. And we submit that in any election, there can only be one result. I beg your pardon? No. Collating was to be of the 290 by IEBC, but Your Ladyship, it is important to bear in mind where we were coming from. And that is why I took a moment, Your Ladyship, to walk the court through the provision of the provisions or the finding of Kriegler's report. The result is one. In any election, in any election, there is one result. It is a tally of several different components. Many more for the president than you would do for an MCA, but it is a tally of different components. And there is no result, there is no finality until that final tally is done. To lock the presidential results at 290 different levels would then make that the provisions of Article 138(3)(c) impossible to carry out.